Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Klassen was tried and acquitted of assaulting a police officer. At trial, the judge determined in his criminal case that his rights had been violated when the officer attempted to arrest him unlawfully. After being acquitted of the criminal charge, and after receiving the determination of an unlawful arrest, Mr. Klassen sued the BC government, essentially arguing that he had been assaulted by the officer in the course of the unlawful arrest, and that therefore he was entitled to compensation. In filing the response to the civil claim, the Attorney General of British Columbia filed a response that argued, among other things, that Mr. Klassen had not been unlawfully arrested, even though the court had already made a determination about this. Mr. Klassen applied to strike those pleadings on the basis of the fact that there had already been a prior judicial determination, and the issue was therefore res judicata. He was unsuccessful in his application. He sought leave ultimately from the Supreme Court of Canada, who denied leave, and hence why we're talking about this case today. And this case is very important because it doesn't make a lot of sense in preserving the economic nature of judicial resources for an individual who has been acquitted in a criminal trial, where there's been a finding made by a judge of a breach of a person's charter rights, to then have to relitigate all of those facts in the context of a civil case in order to get a second judicial determination about the same thing. The fact that there was a prior determination effectively becomes irrelevant, which means that court time is wasted by having a judge in one forum reconsider the evidence and arguments and issues that arose in a completely different forum where there was, in fact, a determination on this issue specifically. And after all of the judges that are involved in these types of cases, whether there's a superior court judge sitting in a civil case versus a provincial or superior court judge sitting in a criminal trial, ultimately make a determination based on their jurisdiction to consider charter issues. So it's not as though the law should change as between a BC Supreme Court judge or a BC provincial court judge, or a BC Supreme Court judge sitting on a criminal case and a BC Supreme Court judge sitting on a civil case. And yet, essentially, the ultimate impact of this is that the issues have to be relitigated. It also poses practical hurdles for individuals, though, to relitigate those issues. In a criminal case, you have the opportunity to compel disclosure. Essentially, you get disclosure of all of the evidence against you, and there's a process whereby the Crown is obligated to turn over disclosure. That disclosure can't be used by virtue of implied undertakings in the civil proceeding, which means that everything that you learned in the context of the criminal disclosure process is not something that you can just ask for in the context of the civil case. You have to go through the whole discovery phase, thereby extending expensive dollars. And where governments are the defendants in these types of cases, that means tax dollars are spent arguing over whether or not a document has to be turned over, or whether or not a document or information exists. Plus, the perpetrators of the charter violations have the benefit of having been cross-examined, thereby having the strategy revealed to them as to how the charter breach might be determined. The defendants have the benefit of judicial rulings interpreting certain issues and determining, therefore, whether or not actions were justified. And it raises concerns that evidence could potentially be tailored to achieve a different outcome in the civil forum. Also, this raises questions about whether a different standard of scrutiny is effectively applied to charter-violating actions of police officers in a civil proceeding than it would be in a criminal proceeding where the charter violation could lead to a defense on a charge of assaulting a police officer. All of these things are important issues to consider. And the Supreme Court of Canada, I think, missed an opportunity here to sort of streamline the course of justice. And not giving leave to this case, to my mind, seems inconsistent with the way that they've given direction in Jordan and Cody and other cases lately dealing with delay, that all justice participants have to act reasonably to minimize court delays. That should apply in the context of civil proceedings. Civil proceedings eat up court time from criminal cases, and civil litigants who have to spend more time in court have less of an opportunity to get heard because courts necessarily prioritize criminal cases as a result of the Jordan and Cody rulings. Essentially, all of this creates a significant injustice, an impediment to access to justice, and slows down the course of proceedings in a way that shouldn't occur in these cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.